Hey everybody, George Souris from Empire Legal. This week we're going to talk about related party transfers. Alright, so what is a related party transfer? We're going to unpack it, but basically we're looking at what is a related party and how does that affect the transfer. So let's start with the definition. What we're looking for here is calculating a dutiable transaction in Queensland, so when a property is changing hands, and we're looking for either the higher of the sale price or the market value of the unencumbered property. So what it would sell for on the open market with no mortgage. Effectively here, the Office of State Revenue is looking to collect the transfer duty payable at the true amount. So basically, no tax discounts just because you're related to somebody when a property is being transferred. Let's just jump right into it. Let's do a real life example. My parents have a $1 million property here on the Gold Coast, and because they're such wonderful people, they're going to let me buy it for $850,000, so a $150,000 discount, because they're good people. So, good news, I'm getting the property for $150,000 off. However, if we look at that definition we just spoke about, the sale price is actually lower than the true market value. The true market value is $1 million. So the Office of State Revenue shouldn't miss out on the duty payable, the true duty, which is the stamps on $1 million, not $850,000. Make sense? The transaction with the related parties is not at arm's length because we're involving some parties that are related by blood, marriage, or in a commercial setting. They know each other. If you want to dig a bit deeper into it, this is all governed by a public ruling that was released by the Office of State Revenue. Now, a public ruling is effectively something that the Commissioner puts out to the world. You can see it on the Office of State Revenue's website. I'm going to put the link in the blog itself, which overrides everything prior to, and it's effectively the source of truth of how we assess these sorts of transactions. If we look at the definition of a related party, it lives in Section 61 of the Duties Act, for all of those who like to read the Duties Act in their spare time. 3 different sections, right? We've got an individual, so we're talking somebody that is related, for example, siblings, spouse, parents, etc. Then we've got companies, so shareholders, anyone where there's a relationship there between, say, business partners or family members within the corporation that could be defined as related, and trusts. So if we are talking about companies and trusts with transfers, if the beneficiary has a relationship with a family member there, we've got a related party as well. But you can read up on the exact definitions by Googling it or looking up that Duties Act. That gives you a brief understanding of these definitions of related parties. You've got 2 ways for us as self-assessors on behalf of the Office of State Revenue, as the solicitors, we are obliged to either get a registered valuation from the related party or 3 comparative sales. Now, the registered valuation must be from a registered valuer, and we have to hold that on file for 5 years. Alternatively, we can ask a real estate agent to get 3 comparative sales arranged in the area. They have to be true comparatives, and we're going to be looking at the highest of those 3 values when we do our transfer duty assessment. On this $1 million example, if it was $950, $980 and $1.2 million as comparatives, we're paying stamps on $1.2 million. Also on this report must be the real property description, so the lot and plan, the residential address, and any improvements made to the property. We'll see you guys next week for part 2.